Good morning. Be seated, please. As I did in the first argument, I want to thank Mr. Evans for coming in person, traveling from Colorado, I believe. We deeply appreciate that. You ought to be qualified for a gold medal of some sort, given the current views about COVID here and there. Also, Ms. Clouthier, are you there?
Yes, ma'am, I'm here.
Can you hear us?
I can.
And I will say, I'm sorry you could not appear in person. I hope your health is all right. And I will say that we went to this device for having your appearance by telephone, not to punish you, but because it is a practical solution to the problem that Mr. Clouthier came in from out of town to argue. And I myself had to participate in a Court of Appeals proceeding by telephone a couple of years ago when I was recovering from surgery, and I thought it worked perfectly well. So if at any point you feel you cannot hear the presentation, please feel free to let us know.
Okay, I will, thank you.
And I will say you're excused from having to put your little cover over the microphone, which the counsel in the courtroom here have to do. So with that, I will call case number 19-10350, Salomon versus Kroenke Sports and Entertainment, and recognize you, Ms. Clouthier.
Yes, ma'am. My name is Susan Clouthier, and I represent the appellant, Mr. Salomon.
You can make your argument.
Okay.
You have 20 minutes, and we'll let you know if you're starting to run over.
Okay, thank you very much. May I please the court? I received an email yesterday from the court that this panel is interested in revisiting the Williams and Ryan cases, and since it was not briefed in our brief or the police brief, I would first like to request that the panel allows us to present and file a post-submission brief on the matter to have it on the record. But I would like to start there unless the panel has any requests to start in different place.
You can do the briefing later.
Okay, thank you. But I would like to start, I guess, talking about the Williams and Ryan rule, which was revisited recently in Williams. The court in the dissent had expressed its, disappointment or even not feeling like the issue had really been resolved, whether or not Ryan is still good law, and whether or not that we complete that issue in Williams was very narrow, dealing with the 54B motion, certification, and it's really not very instructive in our case because we're not dealing with a situation where the appellant has voluntarily withdrawn in claims and without prejudice. In the situation here, the party was not represented by counsel as an entity, and a default judgment or default was entered against PNC. Salomon himself did not request that those claims be withdrawn without prejudice. The situation, we believe, because the purpose is expressly stated in Ryan and Williams and in other cases like other circuits, that the purpose of this rule is to prevent parties from voluntarily dismissing their remaining claims as they wait to manufacture final judgment, or in other words, clean the system. And that is not what's occurring here. So what I would suggest is that Ryan should be narrowed to include potentially only cases where the plaintiffs have voluntarily dismissed claims.
Ms. Clouthier, we can't narrow Ryan, though, as a three-judge panel, can we? As a follow-up, is it true that the final judgment that was entered in this case only did not apply to that dangling party, and so there is no final judgment that resolves the issue with that dangling party? So those are two questions.
The final judgment does not specify either way. It just states that the judgment is entered, but what was brought up in the dissent in the Williams case was that you really can, under Rule 41A, dismiss only one party or only one claim, and that Rule 55A would be the proper rule here, and then of course the jurisdiction can be given under 28 U.S.C. 1291, as the dissent mentioned in Williams. That statute is broader and actually includes not just a final judgment but a final decision. There's a distinction, as was mentioned in the dissent, page 369, that final judgment and final decision are different, and final decision is broader. If there's nothing left to appeal and nothing left to litigate at the end of the case when the final judgment is entered, that would constitute a final decision. And in this particular case, because the default was entered several years, at least 2 years prior to the judgment entered in the case, there would be nothing left for the court to do at the district court level but to just enter a judgment either way and order either way on that default.
But it did not do so.
But Ms. Clouthier, I don't wish for you to use up your entire argument on this subject. I think that would be most unfortunate, given the fact that you're allowed to file a post-argument brief. I would throw out this suggestion. I'm not diminishing the importance of this issue, appellate jurisdiction, but it seems to me this is more like those cases where parties appeal and the court discovers that no final judgment was entered formally under Rule 58, in which case, as I recall it, our practice is just to hold open the case, have a limited remand, get the court to enter the final judgment, and then we proceed forward. So in your briefing, I would appreciate if you'd consider that possibility and then move on to the important issues you've raised.
Okay.
Rule 58. Yeah.
You would like me to step over onto our substantive arguments?
Well, I assumed you would want to do that.
I would like to, I just wanted to make sure that the court was satisfied with our position on the jurisdictional issue, and I will submit a submission brief on that. I'd like to start with a breach of contract claim. That's the claim of the primary criminal case, and the term sheet was part of the contract that was breached. And it has an exclusivity provision, which I'm sure the court has analyzed very carefully. But where the district court went wrong is finding that the breaching section A2 was contingent on breaching section A1. But the plain language of that term sheet does not support that conclusion. It does not state that you have to breach the section A2 in order to breach section A1. There were a couple issues that were raised in the order. One being that the contract was unambiguous. The position of the appellant is that the court does not have the authority to determine ambiguity as a matter of law. Case law, such as matter of Roadster and a number of other cases we cited in our brief, state that whether the contract is ambiguous. It's a fact question. It's not appropriate for summary judgment.
But at a hearing, you said it was not ambiguous.
Well, that's something I could adjust as well, because at that hearing was not related to this motion for summary judgment at all. It was a Daubert hearing.
But it doesn't really matter. It means as a judicial matter, you've waived the issue of ambiguity. You've waived the right to raise that issue.
Respectfully, the counsel that represented Salomon at that hearing did not make that statement as an intentional waiver. The case law supports that in order to waive a right to raise an issue later, it does have to be an intentional waiver. He did expressly state in that hearing that he was not ready to have a hearing on the motion for summary judgment. It was simply a issue of the Daubert limited to that motion. So I believe that was not an intentional waiver of that issue. And so even if that were out of the question, there was still sufficient evidence raised that the term sheet was brief. The parties did not include Mr. Salomon in the March 21st letter. The court made a legal determination that was unintentional. The credibility determinations are in the jury's decision. It's not a rule of law that is undeveloped. It's very developed in both Texas law and also in federal court.
Opposing counsel argues that the court did not make a determination that it was unintentional, and that in any case, it's irrelevant whether it was unintentional or not. Well, how do you have a fact issue here?
Well, the fact that they did not, that they left him off the letter to try to, and there's an inference that can be drawn that they left him off the letter to circumvent the exclusivity provision. They also, I apologize, I know it's the same way I was just standing there. They also, there's some testimony throughout the discovery process that Mr. Salomon was identified as a party to the term sheet, which was a violation of the exclusivity provision. Then also evidence was shown that KSC obtained a copy of the term sheet prior to its expiration. There could provide inferences that that it was an intentional, that they intentionally left him off.
Well, even if they did intentionally leave him off, that extension did not become effective. All parties agreed to that, correct?
Could you repeat that, please?
Even if Mr. Solomon's name was intentionally left off of the March 21 letter, everyone agrees, do they not, that that letter had no binding effect for that reason?
That the letter had no binding effect.
Right.
But the letter in itself is inferential evidence that the exclusivity provision was breached because they were not allowed to solicit or encourage or accept or facilitate or any potential offers for the subsidiaries. So the fact that the letter was even in existence, that in itself is circumstantial evidence that can be, that a jury could infer that they were attempting to circumvent the exclusivity provision and actually breached it.
Well, but they didn't, because in the end, when Kroenke bought out the parent company, nothing happened to. I get the companies confused. The one that Salomon was running Outdoor, right? Or no, ACB.
Correct. That's the two camera companies.
But I mean, Kroenke bought out the parent company, and all of the stock of the subsidiary went with it. But nobody interfered with Solomon's attempt to purchase the subsidiary. It just fell apart.
I don't believe that the evidence is as that clear as a matter of law. The standard that the court focused on, the sale of stock assets of a parent company do not equate the sale of the entity subsidiary automatically. That is a rule of law. However, the different evidence that was presented by Salomon did show that there was discussion about obtaining a subsidiary which is a breach of the exclusivity provision. I believe it just fell apart because of the purchase of the parent company. The provision that was entered into with Salomon did didn't go away just because the parent company was sold.
What evidence do you have in the record that you point to that they interfered with the company? You said there's some evidence in the record. What is that evidence specifically?
There was a meeting on March 5th, 2013 that they discussed the potential sale of the subsidiary with KSC and the outdoor discussed the potential sale of the subsidiary. The deposition testimony is that outdoor discussions to sell the entire company included the subsidiary. David Clark of KSC testified he believes that the offer to purchase outdoor, the parent company also included ownership interest in the subsidiary. The Clouthier General Counsel had called Salomon to inform him the position with disregard to term sheet because the interest of outdoor was just such an offer to purchase the entire company as a precedent over the sale of the subsidiary company. There was enough evidence that they were purposely trying to push him out of the picture, and that the purchaser of the parent company had the desire to purchase the subsidiary, and that Salomon did present adequate evidence to show that was indeed happening and what did occur. Whether or not a jury decides to find in favor of him is not summary judgment appropriate. The actual facts itself in the discovery show that there were definitely discussions that the subsidiaries would be sold as well, and that is a direct violation of exclusivity.
Did your brief give record citations for this evidence? I don't recall.
Yes, ma'am. That would be starting around page 20 in our opening brief and goes through about 20 to 23, and it does have citations to the record for those. Is
most of that evidence found in the response to the summary judgment motion?
I did not notate that in my notes. I can tell you the page number if you'd like. I don't have that.
Oh no, I'll take your word for it if it's in the blue brief.
It's in the opening brief that we filed in August.
Okay.
And I believe I'm running out of time unless the court would like anything further on that, and I could reserve a few minutes for rebuttal.
That would be fine. Your timer is very good, and you have reserved time for rebuttal. Thank you.
Okay.
Mr. Evans?
Thank you, Judge. please the court, Judge Jones, Judge Smith, Judge Elrod. Again, my name is Kevin Evans. I am here from Denver, representing Kroenke Sports Entertainment and Outdoor Channel Holdings. And I very much appreciate the opportunity to present here in person. Not all courts are doing it. I traveled extensively last year in deposition, but not once in a court hearing. So I assume. So I really appreciate the opportunity. I know you raised a question yesterday on the jurisdictional point, and I want to touch upon that briefly because I think, Judge Jones, your resolution or suggested resolution probably takes care of it, but this may be the one area in the case where Mr. Salomon and my clients agree, which is I don't think Williams, as I read it yesterday, I don't think it overruled Galactica Star or El Talawi. And therefore, I think those cases are still good for the proposition that a final judgment, which was entered by Chief Judge Lynn, a final judgment does not need to recite Rule 54B. And it doesn't need to say this is pursuant to Rule 54B. I mean, that's what Galactica Star says.
But it can't be a final judgment because in the same day, Judge Lynn issued an opinion that said, you go do some business with this other claim. So it wasn't, we mean to cover everything and it just didn't, or that there's some kind of mistake. She intentionally didn't put that other entity in there because she had given them some homework.
Right.
So how does that affect this analysis?
I apologize, Judge Elrod. She did give them some homework, as you say, which they ignored.
Yes.
Having said that, I think the unmistakable intent from her order and from the record, and that's the language from Galactica Star, I think it actually cites a previous case, a hamburger case, which I forgot the name of, and the El Talawi case, all stand for the same proposition. The El Talawi case was decided last year. I don't know whether it was before or after Williams. I didn't really dig into it that closely. I should have. But I don't think that Williams rejected the proposition that the final judgment can be, which she called the final judgment. I think that's what it says. It's necessarily unappealable if the unmistakable intent, which is the language of those cases, of the district court was to enter a final judgment for less than all parties and all claims. And I think, having been involved in this case from day one, having appeared before Chief Judge Lynn a couple of times, I think that was her unmistakable intent.
But you have no problem, though, with a limited remand, just to make sure, do you?
No.
And you, both attorneys, I hope understand what we mean by limited remand is that this panel keeps the case, it goes back down, there's an order entered, presumably by the district court, and then there doesn't have to be a new notice of appeal or new briefing or anything. It's a fairly efficient way of clearing up any difficulties.
Right, it is a very efficient way, and I have no objection to that. It was my concern was, oh my gosh, are we going to have to brief this thing again and educate new panel members? And if that's not my understanding of how this works, and so I have no objection to that process. And Solomon, Mr. Solomon will get no objection from me along the way. So I promise that.
Clouthier, can you hear all right?
Yes, ma'am, I can hear.
Great, thank you.
So now what I'd like to do is I'd like to turn to the actual substance of this appeal and correct a few things. I'm not going to have the time, in 20 minutes I can't correct all of the issues that exist with the liberties that were taken in the briefing with respect to the record, but I want to hit on a few. But before I do that, I would like to just, and the court's already indicated it's aware of this, but for over a quarter century, the law in Texas and the law in the Fifth Circuit has been that the sale of the stock of a parent does not affect the stock of the subsidiary, in this case a two-tier subsidiary because it was 2 tiers down, or the assets of the subsidiary. And the Capital Parks case is very clear on that from this circuit. The DocuData and Tenneco case from Texas state courts are very clear on that. And what I found interesting is that Mr. Salomon in his opening brief didn't even attempt to tackle those cases particularly in light of the decision by Chief Judge Lynn. But be that as it may, they made that decision to ignore those cases. I didn't. They're dispositive. And the bottom line here is that before February 27, 2013, what's the significance of that date? It's the date the term sheet was fully signed. Before that date, on April 16, 2013, the significance of that date is it was the day after the exclusivity period expired. On May 18, 2013, the significance of that date is that was the date after the KSE subsidiary acquired all of the outdoor stock and merged into outdoor. The aerial camera business was owned during that entire period of time, even after the merger, was owned by Wintercom Inc., which is a subsidiary of outdoor. The undisputed evidence in this case, and it is undisputed, is unrefuted. KSE never made an offer to acquire the aerial camera business. The offer letter on February 27, which Mr. Salomon attaches, I'm sorry, Judge Elrod, do you have a question?
No, you go ahead and finish your sentence.
Okay, which he attaches as Exhibit C to his second amended complaint, made it clear it was only a stock purchase for outdoor stock.
Assuming, arguendo, that we recognize completely this proposition about the parent and the subsidiary, did Outdoor indirectly solicit or encourage Kroenke to make an offer for the ACB by attempting to provide veto rights in the March 21st letter?
No.
Can you address that?
Yeah, I'll be happy to address that. First of all, in order to do that, I will correct something, which is there was a judicial admission made by Solomon's counsel, Mr. Ibrahim, who was affiliated at the time with Mr. Avenatti. There was a judicial admission made in Daubert hearing that this term sheet is unambiguous. And as Judge Smith rightly pointed out, it doesn't matter whether it was a Daubert hearing or whether it was a hearing on the motion for summary judgment. It was in response to a direct question from Chief Judge Lynn that it was unambiguous. And the significance of that was it resulted in the exclusion of our expert.
What does the association with Avenatti have to do with it?
It's really nothing other than the fact that they were representing him. Mr. Avenatti did appear on telephone conferences. He was not at that hearing.
You lie down with dogs, you get up with fleas, that's all. Sorry.
Yeah, and I didn't mean to take it. They were just the trial counsel, both of them. And they both appeared at various hearings. And so getting back to Judge Elrod, your point, this was an unambiguous contract. And what does the term sheet say? The term sheet says, shall not directly or indirectly do a number of things, right? Correspond, negotiate, solicit, sell, or agree to sell, equity or debt interest of the aerial camera business or material part thereof. It doesn't say, and in light of the intermedia existing term sheet, merger agreement with Outdoor, it couldn't say, oh, by the way, you can't sell outdoor stock. It's not what it said. It couldn't say that. So under rules of construction, directly or indirectly modify what comes immediately afterwards. Cannot directly or indirectly negotiate. Cannot directly or indirectly correspond with. Cannot directly or indirectly sell. That's what it means. It doesn't mean that you can't sell the outdoor stock, which then somehow indirectly results in a sale of aerial camera business, because as a matter of law, that just doesn't work. I mean, to use a tautology, a corporate parent can't either directly or indirectly sell a subsidiary unless it sells a subsidiary. And that didn't happen here. And so the March 21 letter, which, by the way, the undisputed evidence from Catherine Lee, who was the general counsel of Outdoor, I took her deposition. The undisputed evidence is that KSE had nothing to do with that March 21 letter. She drafted it. She didn't communicate with KSE about it. KSE didn't know about it until after the fact, notwithstanding the efforts that Mr. Salomon makes in his briefing to suggest to the contrary. The unrefuted evidence is that Yeah, they may have learned about the March 21 letter after the merger agreement, but before they actually merged. That may have happened. In the due diligence process in connection with the data room, I think it was in there. And there's no dispute about that. So they did learn about that, but it had nothing to do with KSE's purchase of outdoor stock. The March 21 letter is a complete red herring.
Well, more to the point, I mean, I'm inclined to agree that it may not have any legal force here, but frankly, it's hard to conceive why Outdoor Channel's general counsel neglected to put Mr. Salomon, since it was his idea, or allegedly the company had approached him about a buyout of the aerial camera business, and Pacific was his financier. It just seems very unlikely that the general counsel for Outdoor inadvertently overlooked that. Whether that implicates your client is another matter.
Well, and all I can say, Judge, is the undisputed evidence indicates that it was an oversight. That's what she
It was an oversight just because she said it was an oversight, but there's no other credibility involved there, right? Is there?
That's what I'm saying. I mean, I just, and you can question whether that's true or not true, I guess, at this level. The fact remains that the March 21 letter is just a red herring. It has nothing to do with this case other than to try to create a fact issue. And on that score, I'd like to correct something that Mr. Solomon's counsel said to you today and said in the briefing. And this, I think, highlights the liberties that are taken with this record on this appeal. It illustrates it perfectly. Mr. Solomon's counsel said that there's evidence in the record that Mr. Gluck testified during his deposition, in which I was there, that he believed that there was going to be, the purchase of the outdoor stock was going to be a purchase of the aerial camera business. Interestingly, they cite to one page of his deposition transcript and conveniently omit the page right before it. And what does the page right before it say? The page right before it is a question asked by Mr. Solomon's counsel. Did you ever have a conversation with Mr. Hornish, the CEO of Outdoor, or Mr. Allen, the CFO of Outdoor, in which you said that KSE was going to purchase the aerial camera business? What was Mr. Gluck's response? And this is the page that was attached to the appeal brief, or to the record, but which isn't complete without knowing the question. And what did Mr. Gluck, how did Mr. Gluck respond? He says, I don't believe I ever made that statement, nor would I have made that statement, because it's the purchase of the subsidiary, or the parent stock is not the purchase of the subsidiary. So Mr. Gluck, despite the fact Mr. Salomon wants you to believe he testified to that, he denied that. And that is in the record. And it's in the record on appeal. And yet they perpetuate that myth here in oral argument. There's some other liberties that are taken in the briefing and suggested during today's argument. I'd just like to touch on a couple of them, because I don't have time to touch on all of them. But on page 20 of the opening brief, Mr. Salomon claims that KSE negotiated for and obtained an equity interest in the aerial camera business. The undisputed evidence is that KSE never, ever made an offer to acquire any aspect of the aerial camera business. It was only the stock of Outdoor. The undisputed evidence is that Outdoor did not negotiate with KSE about acquiring the aerial camera business. Ms. Lee, the general counsel, testified about that at page 3566 of the record. And this is all in our brief. Roger Warner, the co-chairman of Outdoor, it doesn't get much higher than that, testified those negotiations never occurred. And the merger agreement and the offer letter make it clear that this was only a purchase of Outdoor stock. Mr. Salomon claims in his opening brief on pages 11 and 40 that there was a pending sale, his words, not mine, pending sale of the aerial camera business. And that, quote, ACB would have been sold to Salomon, but for KSE and Outdoor. That's just pure fanciful thinking. The record doesn't support that in the least. Here's what the undisputed evidence shows. There never was an agreement between Outdoor, Salomon, and PNC to purchase the aerial camera business because they couldn't come to terms. On March 5 of 2013, Outdoor sent an asset purchase agreement to Mr. Salomon and PNC. And within 2 weeks, before, by the way, the March 21 letter, within 2 weeks, PNC sends back what Mr. Hornish, the CEO, characterized as a sea of red. When I took his deposition, those are his words, sea of red. He said there was no meeting of the minds on what we were willing to agree to and what PNC and what Mr. Salomon wanted. And then Catherine Lee testified, the general counsel, that the changes were, quote, very, very, very extensive. Her words again, not mine. And that they were not anywhere close, quote, to a pending sale. And that's what precipitated, as the record reflects, the March 21 letter, to try and give them more time to do this. And yet they want to turn it back on us. The other interesting point about all this is that Mr. Salomon claims on page 19 of his reply brief is that PNC, quote, had more than enough funds available to finance the transaction. So what? The undisputed evidence from the PNC representative himself, Jeff Holloway, whose deposition I took, is that PNC was not, not going to fund the entire purchase price. And Salomon admitted that he wasn't contributing funding. That's on, and that he didn't have the resources. And that's in his response to request for admission number 26, which is page 3349 of the record. Again, that's why they went to find, or try to find, other investors. Mr. Salomon and Mr. Holloway went on an effort to try to attract other investors so that they could fund the acquisition of the aerial camera business. And no one would contribute money. No one would help them fund the acquisition. They didn't have the money to buy the aerial camera business, even if they had reached an agreement with Outdoor on the terms, which is highly questionable given the sea of red and the other characterizations of their revisions. So, and then finally, the only other point I'd like to make, or two other points quickly, is on the reply brief on page 8. Mr. Salomon says that KSE, quote, was presented with the opportunity to approve the deal and, quote, chose to delay and not to do so. Again, another extreme liberty taken with the record. KSE wasn't presented with anything to approve or not approve. There was no definitive agreements ever reached between Outdoor and PNC and Salomon, so Kroenke didn't veto anything. And then finally, on page 23 of his reply brief, Mr. Salomon suggests that he and PNC were in lockstep and that PNC never objected to this 8% equity proposal that was made by Salomon, which also bleeds into the expert issue, which I don't intend to address today unless the court has issues about it. But Mr. Salomon testified, when I took his deposition, that there was a significant, his words again, quote, significant difference of opinion between himself and PNC about the equity share in the proposed purchaser. That's on page 3704 and 3705 of the record. So far from PNC never objecting, Mr. Salomon himself admitted during his deposition that there was a significant difference of opinion. They were, between the two of them, they couldn't come to an agreement on who was going to have what, and again, they couldn't come up with the purchase price. So Mr. Salomon's case, if I can call it that, is founded on pure speculation. I mean, he says, hey, it must be conceivable that KSE instructed Outdoor to prepare this March 21 letter. And it's likely, I'm using his words from his brief, his opening brief, 30 and 32, it's likely that Outdoor was induced by KSE. There's not a shred of evidence in the record to support that fact, Your Honor. It's just all speculation. And this point about inferences have to be reasonable. And you can't just ignore the record. Unless the court has any other questions, I'm out of time.
Fine. No, that's fine. Thank you very much. Okay, Ms. Clouthier, do you
Yes, ma'am.
rebuttal? Do you have any rebuttal?
I have just one quick thing on the jurisdictional issue. My only concern with limited remand, one primary concern is that under Rule 55, entry of default is discretionary for the district court. So in doing that, making that the rule, it could potentially leave the case in procedural limbo. It's mentioned in Lewis' case under 2001 236 at 3E 766. That could eventually just leave this case forever in limbo. So I would suggest that might not be the proper procedure in that situation. And then one thing to go back to his opposing counsel's argument about how we misrepresented the record on Flex deposition testimony. When there is a witness that has conflicting statements on whether it be in testimony at trial or testimony in the deposition, the credibility of the statements is for the jury to decide and not for a court. And it is explicitly on page 30 of the deposition, which is page 4346. And it states, you are aware that KSU was questioned by Salomon Counsel. You're aware KSU made an offer to purchase outdoor channels, correct? He said yes. And that offer was made on February 27th, correct? And he said, sounds right. He goes on to ask him about the shares. And then one of those, and then it outdoor owns several subsidiaries, correct? And he says, yes, one of those subsidiaries is Southhand, yes, to go through those two. And so when KFC made an offer to purchase all shares of Outdoor Channel Holdings Inc., that included any and all ownership interests that Outdoor Channel has at any of its subsidiaries, correct? He said, I believe so. So if at any point during the deposition you see something to the contrary, that is a credibility issue for the jury to decide. Because that statement in itself, it indicates that he believes that he was purchasing the subsidiary. The fact that Texas law recognizes that the sales stock or parent company does not automatically purchase their subsidiaries, that does not apply here because if the actual person or company purchasing the parent company is also agreeing to purchase the subsidiaries or believes that it is doing so, that is a separate issue. And then also there is a lot of evidence that is, the language of the term sheet, whether they directly or indirectly. So indirectly is not, the fact that that was included in there means that all of these circumstantial evidence issues are relevant. But the fact that they indirectly solicited or they indirectly facilitated the purchase of the subsidiaries prior to the expiration of the term sheet does raise a fact issue. They have knowledge of the term sheet that's in the record, that's in the brief. As a part of KC, when after they purchased Outdoor, they immediately issued a press release mentioning the sale of the aerial camera businesses. As part of their publicity, all of these facts, along with the March 21st letter, in itself, does raise the issue of whether or not they indirectly breached that term sheet.
Well, but excuse me, ma'am, but the term sheet is between Outdoor and Salomon and Pacific Northern. Kroenke is not a party to the term sheet.
I understand, but I'm not going to go into a full brief on that issue.
Okay.
We did, if you want to go back to the brief, we did talk about how they were also liable for the particular reason that we outlined in that brief, because they were party to a lot of these conversations. And the actual actions of KFC with Outdoor, they also breached the is evidence that there was potentially collusion, there was potentially an actual, like they intentionally left him off that sheet, that letter, those things are not resolvable by summary judgment because there's competing credibility issues and credibility between witnesses is not a decision as a matter of law. I mean, they're not, these issues are not substantial. They're pretty substantial, so if you look at it in the totality. Just the counsel, the panel has some more questions, I can help.
Okay, no, thank you. We appreciate your participation in this way. We appreciate Mr. Evans for showing up, both sides. Why, Ms. Clouthier, since you're the appellant, why don't you send us your post-argument brief on appellate jurisdiction, and Mr. Evans, you don't have to file anything unless you feel moved to do so. So with that, that's the conclusion of the second argument of the day, and the court stands in recess until 9 o'clock tomorrow morning.